Hi, my name is Danya Bundy. I'm an attorney at the Bundy Law Office. I deal primarily with individuals who are going through a divorce and where one of the issues that is at hand is child support.
My name is Aaron Bundy. I work here at Bundy Law. I'm licensed to practice in Oklahoma, New York, and the District of Columbia, and we're going to talk about child support and financial support or alimony.
The first topic that we're going to talk about is child support and how that is calculated here in Oklahoma. Oklahoma has a child support guidelines that provide a amount at the bottom once we put in certain data, and that data includes gross income of the parties, number of overnights, and health insurance premium for if any is paid. Now the guidelines are used if the gross income of both parties is below $15,000. If the gross income of both parents is above $15,000, then we deviate. And what I mean by deviation, there are other factors that we take into consideration when determining how much child support one parent is to pay the other parent.
Can you speak a little bit more as to what puts us at that level? Is it when both parents' incomes exceed $15,000 or when one exceeds?
It's when the combined income of the parties is above $15,000.
Okay. Then what does that look like?
Well, then, like I said, we deviate and we take into consideration other factors. And what I mean by factors is there private school that one parent is paying? Is there extracurricular activities, uniforms, choir, camps, summer camps? Are there childcare costs that one parent is paying for the other parent when they're at work? Nannies, au pairs. There are an extreme amount of factors that can be taken into play when determining how much child support is given to the other party. Now, what is child support supposed to be used for? And there's not a set definition, but it's for the necessities of life for the child or children. And that includes food, clothing, housing, shelter, and any needs to promote their well-being and their life and the lifestyle that they're used to.
So just backing up a little bit, in a child support calculation where the combined incomes does not exceed $15,000, are the things that you just talked about, such as extracurricular activities and other expenses, are those taken into account when you're just running the calculator without doing this deviation that you mentioned?
Yes, they are. They're not negated just because the gross income of the parties is below $15,000. It's just that below $15,000, there's a rebuttable presumption per law that the guidelines should be followed. Now, oftentimes what we do is we do deviate, even if the gross income of the parties combined is less than $15,000, because there are those extracurricular activities that cost way more and are more burdensome for one parent as opposed to the other parent. I'm going on a rant and talking really quick, but these are issues that we face every single day, and what parties face every single day with, when they come to us. How is child support going to be calculated? What is included? And how can I provide the best life for my child at both parents' homes?
So when the parties' combined incomes is $15,000 or less, it sounds like we have a good figure to look at for what child support is likely going to be.
Yes.
Is that not the case when the combined incomes exceed $15,000, and is there a cap?
So the guidelines, if it's below $15,000, yes, that's typically what the courts and judges follow. Above $15,000, there is a cap. There's a formula that we oftentimes use, and it's called the Smith formula for individuals who have incomes that are above $15,000. And that kind of gives you a percentage of gross income. It takes into account the percentage of each parent and economic standards that the Oklahoma law has put into place. There's a statute in place that we take numbers from. But even at that, taking that into consideration, there are always extracurricular activities that children are in. Non-covered medical. If one parent is paying 100% of non-covered medical expenses, that's to be taken into account regarding child support.
So you've talked about extracurricular activities, which can quickly exceed the calculator's monthly child support amount. Does this also apply to to private school, travel, and other things that, depending on the child, may be a part of their routine.
Yes. And so a big extracurricular activity that we oftentimes see is dance for girls and out-of-state competitions. And with that comes associated the transportation, the cost for the hotel down at the competitions, the uniforms. And that can sound like maybe just an expense here and there, but it adds up. They have solos, they have to pay for uniforms, for specific uniforms. And so those are all things that need to be taken into consideration.
So now we're going to talk about spousal support, also known as alimony. Unlike child support in Oklahoma, we do not have a calculator or a mathematical guide or formula to calculate alimony in any given case. It's an extremely fact-sensitive inquiry, and it's based on a number of factors. From a very high level, the factors are need and ability to pay. And so what that means is there are cases where one side can demonstrate a need for alimony, but if they cannot demonstrate that the other side has an ability to pay that alimony, then they may not receive the alimony that they need, even though they've demonstrated part one, and vice versa. So from there, those two high-level factors break down into a number of case-specific factors and concepts, including the age and means of the parties, their respective incomes, and even their separate resources from before the marriage or any inheritance or gifts that they've received during the marriage. It also includes their educational background and what else?
Ability to go back into the workforce. What is it going to take for that individual to go back into the workforce and make a living and earn a living that is sufficient to allow them to live their life?
Yes. So it's very fact sensitive. All of those factors kind of lead to, can this person work and earn an income independently? So generally, spousal support is viewed as a transitional concept. How does the spouse who needs alimony exit the marriage, and what does it take to get them to a point where they are self-sufficient? Obviously, there are going to be cases where some of those factors or ideas are more important than in others. In an extremely lengthy marriage, you may have a spouse who is effectively not going back into the workforce. Oklahoma does not recognize indefinite or lifetime alimony. We have what is called a some certain requirement, and that means that the trial court is required to determine and identify a fixed amount of the total alimony awarded and then break it down in terms of payments, whether that's on a monthly or quarterly or annual basis.
Now, when you're calculating support alimony, do you go off of the gross income of that individual, or is it net income that you take into consideration?
Well, it depends. Calculating ability to pay and need all are also fact-sensitive questions because it could vary depending on the incomes and resources of the parties. You may have an unemployed spouse who has a large number of assets and separate interests that expose them to a spousal support obligation. So it's going to be very case by case and situational. Generally, you're going to look at net income, all other things being equal, to determine what they actually can pay after taxes.
What do you advise if an individual came into your office and they are the one who is going to pay support alimony because they're the breadwinners? What do you advise them to do, if anything?
I look at a couple of things. One, I want to identify the level of our exposure, and we're looking at a number of factors I've already kind of highlighted that it's hard to quantify exactly what all the factors are going to be because it's going to vary so much depending on the circumstances of each marriage. But generally, I want to look at the disparity in their respective incomes and resources, and I want to look at the length of the marriage and educational background. In other words, what does that exit look like for the other spouse? What is our potential exposure here? And then I want to work on mitigating that. how can we set this up? How can we structure our settlement negotiations in a way where we're setting the other side up to succeed in a way that minimizes our spousal support obligation for the long term? That may, in some cases, be painful in the short term, but it can help reduce a long-term, very expensive and arduous alimony obligation. The other thing I would look at when I'm considering a client who is potentially exposed to a spousal support obligation is being realistic. I view all contested matters as a matter of credibility in the courtroom. So it can be a difficult sell to go to a judge in certain cases and say they should not get any alimony when the circumstances really seem to indicate otherwise. So even when those issues are really highly contested, sometimes it's better to go into court with the view that you are going to pay something and to be able to justify that rather than just say zero and leaving it up to the judge, who may be very generous depending on the other side's claim.
Can property sometimes be given to one party as opposed to payments, such as like $2,000 payments a month?
Sure, the court's going to have a lot of discretion in terms of allocating those resources to, once that need's been established and an ability to pay in some regard is determined, then the judge is going to have a lot of discretion and ability to shift resources, income, even, again, separate property and assets over to the spouse that has need to kind of balance it out.
Are there any circumstances that could terminate support alimony for the individual receiving it?
Sure. It's a little bit of a myth that remarriage of the receiving spouse is an automatic termination of spousal support. That's not necessarily the case, but Oklahoma law does provide for modification of alimony when circumstances warrant. That could range from reduction in the payor's ability to pay or a reduction in the recipient's need. Those are going to be extremely fact sensitive as well.
What if someone comes into the state of Oklahoma, has resided here for 6 months, and has a prior support order from the state of California? How do you address that?
So under the Uniform Acts, those are going to be enforceable obligations and things that we deal with here often. Unfortunately, we don't have the power to modify those awards from other jurisdictions. That's going to be an issue for the home jurisdiction that initially set the obligation.
Well, thank you.